quorum is present. The hearing of the Workforce Protection Subcommittee on H.R. 3582, the Fair Home Health Care Act, will come to order. Pursuant to Committee Rule 12A, any member may submit an opening statement in writing, which will be made part of the permanent record. I now recognize myself, followed by Ranking Member Joe Wilson for an opening statement. So I thank you all for coming. And as I said, 9:30 is kind of off step around here, so you'll be surprised. The other members will come in and go, oh my goodness, I've missed a half hour of this. But we're going to be hearing H.R. 3582, the Fair Home Health Care Act, which provides home health care workers with minimum labor protections under the Fair Labor Standards Act. I introduced this legislation in response to a recent Supreme Court decision, Long Island Care at Home Ltd. Versus Evelyn Coke, where the court found that Evelyn Coke was not entitled to the minimum protections of FLSA, particularly overtime pay. Senator Harkin has introduced a companion bill in the Senate that is exactly like this bill. Evelyn Coke, who unfortunately could not be with us today, worked as a home health care worker for Long Island Care at Home for a for-profit home health care agency for 20 years. Home health care was her vocation, and she worked an average of 42 hours a week caring for the elderly and the disabled. Sometimes she was required to work 24-hour shifts, but she was not paid overtime during her 2 decades of work. The Supreme Court found that Ms. Koch fell into a narrow exemption created by Congress in 1974. Ironically, when Congress created the exemption, it did so in the context of expanding FLSA. They were expanding it to cover most domestic workers, such as chauffeurs and housekeepers, who previously had no labor protections. The congressional record from that period shows that Congress did not mean to exclude home health care workers, but only those workers who provided ad hoc services for the elderly and disabled, only for workers who were, quote, babysitters. So it was a mistake, and it needs to be corrected. Nonetheless, the court found that Congress's intent was not clear and that it meant to delegate the details of the exemption to the Department of Labor. And it upheld a Department of Labor regulation that exempted caregivers who worked for third parties from FLSA protections. So I suppose we could argue whether the Supreme Court's decision was technically correct, but I do know that it was bad policy, absolutely. And if it's allowed to stand, it continues the exploitation of a segment of America's workforce, mostly made up of women and minorities, a segment that does really important and difficult work and barely making a livable wage. Moreover, there is nothing in the decision that acknowledged what most of us know, that home health care has changed drastically since 1974, when caregiving was largely provided by family and friends. Today, about 2.4 million workers are employed by nursing homes, home health care agencies, assisted living, and other residential facilities. Over 800,000 of these workers provide in-home care. As the baby boomers age, this need is going to grow hugely. According to one estimate, in year 2000, 13 million elderly needed caregiver services. By 2050, this number will grow to 27 million, from 13 to 27 million. And the disabled population needing care is also going to grow during this period from 5 to 8 million. And I doubt very much that they've taken into consideration the returning wounded Iraqi vets when they come up with that number. So today already there is a shortage of home health care workers. Turnover is very, very high, and nearly 1/2 of the home health care workers leave their jobs each year. So this in turn impacts the quality of care for people, and in many cases disrupts their care to the point where they are unable to stay at home. And the main culprit is low pay. The average home health care worker makes less than $10 an hour, about half of what other workers earn. More than 20% of home health care workers actually live in poverty themselves and need public assistance just to make ends meet. I mean, that is just unacceptable. And oftentimes, they do not have the work benefits that most of us rely on, such as health care, vacation, and sick time. This work is difficult, it's taxing both physically and emotionally, and must be honored. So I know that there are those who worry that if we pay home health care workers a decent wage, the disabled will not be able to afford in-home care. And I know that there are others who say that Medicaid and Medicare costs will soar, which will ultimately mean a huge cutback, a cutback in services for those who need it the most. But in some states, such as Michigan and Minnesota, they already pay overtime to home health care workers, and certainly the sky has not fallen in those states. It's working. Those states recognize that it is simply morally reprehensible to exclude hardworking home health care workers from minimum labor protections. They also recognize that these protections help to stabilize the workforce. So H.R. 3582, the Fair Home Health Care Act, restoring minimum wage labor protections, will be debated today. We will have the hearing. We will ask you questions. But I want to make sure everybody knows that this bill does not cover occasional caregivers. It doesn't reach live-in caregivers either, because they're already exempted from overtime, but not minimum wages. It simply ensures that home health care workers are paid what they deserve. So I look forward to exploring the issues with you and hearing your presentations, and I honor you for being here. And I now yield to my ranking member, Mr. Wilson.
Thank you, Madam Chairwoman, and thank you for scheduling this hearing at an early hour. I want to commend you on getting people together. Good morning and welcome to our witnesses. Before we begin, I'd like to particularly welcome a good longtime friend and fellow South Carolinian, Mr. Alfred Robinson. I had the good fortune to having served with Alfred in the South Carolina General Assembly as he represented Pickens County, and I particularly appreciate his extraordinary academic background of being a graduate of Washington and Lee University in Lexington, Virginia. I know firsthand of its rigorous standards because I graduated from Washington and Lee several years before Alfred. Additionally, we are fellow graduates of the University of South Carolina Law School, one of America's finest law schools. Turning to the subject of our hearing this morning, certainly one of the most important labor laws in our nation is the Fair Labor Standards Act. Since 1938 and subject to various amendments, the FLSA has provided that a covered non-exempt employee is entitled to be paid a federal minimum wage and be paid overtime at time and a half when he or she works more than 40 hours a week. Since its enactment, the FLSA has been the linchpin of our nation's wage and hour laws and has provided protections to literally hundreds of millions of workers. The FLSA represents the collective wisdom of Congress, the legislators who originally drafted the act and those who have subsequently amended it. Often in these instances, Congress has struck a balance between competing policies. The issue before us today, I believe, is one of those instances. In the Fair Labor Standards Act's amendments of 1974, Congress exempted from minimum wage and overtime requirements certain workers who are, quote, employed in domestic service employment to provide companionship services for individuals who, because of age or infirmity, are unable to care for themselves, end of quote. The 1974 amendment struck a balance between the protection of companionship service workers and the needs of elderly and infirm patients to obtain this care in these services. That balance recognizes that increasing the cost of companion care services by way of minimum wage and overtime requirements is likely to result in a hardship to many who need these services, but for whom they would become too costly. The Department of Labor is charged with administering this law and issuing regulations under it. There has been significant debate and litigation relating to the Department's regulations regarding companion care workers, and specifically the question of whether the law exempts only those workers who are paid directly by the individual to whom these services are provided, or whether the exemption covers all companion care workers, irrespective of the technicalities of how they are paid. Through public rulemaking, the Department of Labor has taken the latter view, that the exemption extends to cover all companion care workers. Earlier this summer, the United States Supreme Court, in a unanimous 9-0 decision known as Long Island Care at Home, upheld the authority of the Department of Labor to interpret these provisions of the Fair Labor Standards Act. They found that the Department's interpretation was a lawful one. The legislation before us today appears intended to overturn that decision. I use the word appears advisedly, and I am glad of the fact that we are having a legislative hearing on this issue and the bill in particular. I am interested in hearing our witnesses today speak about the text and provisions of H.R. 3582. I would like their views as to whether this bill simply voids the regulation at issue in Long Island Care, or whether it in fact goes beyond that. Some have suggested that H.R. 3582 will result in the companion care exemption becoming so limited as to be meaningless. I would welcome our witnesses' views on that as well. It is important as we consider legislation in this area that we are mindful of the consequences of our actions. I suspect we'll hear more today, again, that this is a matter of fundamental fairness for these workers, and I respect those witnesses who hold those views. But as I mentioned earlier, the exemption of certain companion care workers from minimum wage and overtime represents a deliberate choice by Congress. Limiting or eliminating the exemption will absolutely serve to increase cost, not just for employers and agencies, but also for the federal and state governments who pay for these services by way of programs like Medicare and Medicaid. That in turn is likely to have consequences for patient care. These are the issues I'd like to explore today. In closing, let me again say I appreciate the opportunity to examine this legislation in our subcommittee this morning. I welcome our witnesses, and I yield back my time.
Thank you. I'd like to introduce our very distinguished panel of witnesses who are here this morning in the order that they will speak. First, we will hear from Manuela Butler. She has been a home health care worker for over a decade. She currently cares for an elderly woman with dementia who needs round-the-clock care. She is a lifelong resident of Brooklyn, New York. Craig Becker serves as Associate General Counsel to the AFL-CIO and the SEIU Union. He served as a partner at Kirshner, Weinberg, and Dempsey, and taught labor and employment law at UCLA, the University of Chicago, and Georgetown Law Schools. He has written numerous articles on labor and employment law and recently represented Evelyn Coke before the Supreme Court. He is a graduate of Yale College and Yale Law School. Alfred Robinson Jr. is a shareholder of Ogletree Deacons LLP. Previously, he has served as the acting administrator and deputy administrator of the Wage and Hour Division at the Department of Labor. Mr. Robinson was a member of the South Carolina House of Representatives from 1992 to 2002, so we should be referring to you as the Honorable, I'm sorry, Mr. Robinson, the Honorable Mr. Robinson.
He is honorable.
He is. He graduated from Washington and Lee University and received his law degree from the University of South Carolina. Dr. Dory Seavey is the Director of Policy Research for the Paraprofessional Healthcare Institute, where she conducts research on economic, financial, and policy issues affecting the direct care workforce in the long-term care industry. She has served as an investigator at the Center for Social Policy and as a researcher at the Radcliffe Institute for Advanced Studies. Dr. Seavey has been published extensively in a variety of professional publications. She graduated BA from Stanford University and received her PhD in economics from Yale University. William Dunby is the Vice President for Law at the National Association for Home Care and Director of the Center for Health Care Law. He specialized in legal, legislative, and regulatory advocacy on behalf of patients and providers of home health and hospice care. Mr. Dunby has extensive experience in health policy litigation and holds both a bachelor's and law degree from the University of Connecticut. Henry Claypool is currently the Policy Director of Independence Care System, where he focuses on policy that promotes the health and independence of people with disabilities on Medicare and Medicaid. He previously worked at the Social Security Administration and at Advancing Independence, an advocacy firm to promote self-sufficiency of individuals with disabilities. Mr. Claypool also worked at the Department of Health and Human Services in a number of capacities, focusing on disability policy. He is a graduate of the University of Colorado. I welcome all of you. This is going to be a great panel. And for those of you who have not testified before the committee before, let me explain our lighting system. We have the 5-minute rule. When you begin speaking, the light will be green. When you've completed 4 minutes, it will turn to yellow, and that would be a good time to start wrapping up. 5 minutes is the maximum amount of time, but we don't cut you off mid-sentence or mid-thought. I promise you that. But when the red light goes on, please know that your testimony should be complete. So we will hear from Ms. Butler, our first witness.
Good morning. My name is Manuela Butler. Thank you for inviting me to testify today. I'm a home health care
Ms.
worker.
Butler, you need to speak into the microphone.
Oh,
Thank you.
I'm sorry. Good morning. My name is Manuela Butler, and I thank you for inviting me to testify today. I am a home health care worker. I am a member of District Council 1707, Local 389, which is part of the American Federation of State, County, Municipal Employees. For the past 17 years, I have been a home health care worker. It's physically demanding, dirty, difficult, emotionally challenging, but it could be satisfying. I have been deeply touched by all the people whom I have worked and cared for. I am proud of my work. For the past decade, I have worked with a woman who have dementia and diabetes. Mrs. G is 92 years old. I have seen the progress of dementia. It taken away memories. I'm nervous.
Don't be nervous, we're nice.
Okay.
And
It takes away the ability to perform basic activities of daily life. Mrs. G can no longer walk, sit up, bathe herself, cook, feed herself, or clean her house, dress herself, shop for food, or even use the toilet. But because of what I do for Mrs. G, 42 hours a week, for 8 in the morning and to 8 at night, she could live in her home. She's still the queen of her castle. Dementia can change a person, but it will never take away Mrs. G humanity. Because my work preserves her independence. What I do as a home health care worker helps Mrs. G keep her dignity. Mrs. G cannot sit up. She spends most of her time in bed. I bathe her each morning, cook her breakfast. I also prepare her lunch and dinner. I ask her what she would like to eat because like she is in a restaurant. It is a little thing that can maintain independence. Because Mrs. G is in bed most of the day, we must be very careful to prevent pressure sores. Using a mat, a drawer sheet, I move her every 2 hours. Wash her bottom, change her diaper. I also lift her and move her to be showered. I do her laundry, shop for her food, update the visiting nurse and Mrs. G's family. Even though I regularly work more than 40 hours a week, I do not get overtime pay. Uh, Home care work can be dirty, difficult, but at times it could be also dangerous. The past April, Sandy John Paul Bride, a home care worker in my local union, was tragically killed on the job. A mentally ill family member shot her and her client and his family. This young woman was greatly missed by all who knew her. My local union and council are establishing a trust fund for her children. Under my current job, unlike my current job, the agency I worked with before did not have a union. As my old agency, I had no pay leave, no health insurance, and no pension. Thanks to AFNI, I now can take a day off with pay if I am sick. I have health insurance. I have a pension plan. I am paid $9.40 an hour during the week and $11 an hour during the weekends. If the woman that worked the night shift do not come in, I have to work through the night. I will get straight time pay, no time and a half. Under the Fair Labor Standards Act, I will get time and a half for my overtime for doing the same thing for Mrs. G if she were in a nursing home. Because of my work, she could stay in her home, but I am deprived of overtime pay. That's just wrong and unfair. The Fair Home Health Aid Act will protect workers like me who are not covered by the overtime. Minimum wage protection under the Fair Labor Standards Act. Sorry. Okay. In a few months, I will be 65 years old. I don't know when I will be able to retire. I cannot afford to retire. The work I do for Mrs. G is important for the dignity and independence of persons with disability. Home health care workers should be respected, valued. Passing the H.R. 3582 is a good beginning. This year, you raised the minimum wage. Thank you. This increase was long overdue. Now you must help home care workers work with overtime pay. I urge you to pass the Fair Home Care Act. Thank you.
Thank you very much. And Mr. Wilson had something he wanted to say to you.
And Ms. Butler, the persons behind you can't see this, but home health care workers are noted in your profession for having a very pleasant, happy, sincere smile, and you qualify.
Mr. Becker.
Chairwoman Woolsey, Ranking Member Wilson, other members of the committee, thank you for giving me the opportunity to testify here today. When I appeared before the Supreme Court on behalf of Ms. Koch, many of the justices expressed concerns similar to Member Wilson about the cost of protecting home care workers by the Fair Labor Standards Act. I would have liked at that time to turn and point to my client sitting in the audience in a wheelchair being taken care of by her elderly son, so that the justices could have understood the human cost of excluding home care workers from these basic minimum protections. The etiquette of the Supreme Court prevented me from doing that, so I was very happy when you invited me here to testify today. In my very brief time, I'd like to make 4 points. First, when Congress extended the Fair Labor Standards Act to most domestic workers in 1974, it excluded babysitters and employees who provide, quote, companionship services to individuals who, because of age or infirmity, are unable to care for themselves. But it did not intend to open up the gaping hole in the Fair Labor Standards Act which exists today. What Congress intended in 1974 was to exempt babysitters, and we all understand what babysitters are, and something akin to babysitters. That is what the Chief Senate sponsor called, quote, elder sitters. That is, in 1974, Congress understood companionship services to be services provided in a casual neighbor-to-neighbor relationship. Congress explicitly said it did not intend to exempt regular breadwinners, people responsible for their family's support. Since 1974, however, this industry has changed dramatically, not only because the number of home care workers has exploded, but because the nature of their work and their employment relationship has changed. These are no longer neighbors employed on a casual basis, but employees largely employed by third-party agencies, most of whom are for-profit. The exemption is now being applied far beyond what Congress intended. Congress surely did not intend to exempt what is today the fastest growing occupation in the country. Second, there is nothing about what home care workers do today which justifies treating them as second-class citizens, exempt from our nation's most basic employment standards. This work they perform is no less demanding than a file clerk, a nursing home worker, or any of the other categories of employees who are protected by the Fair Labor Standards Act. Despite the misleading term in the statute, companionship services, these workers perform a range of personal and domestic tasks which have already been described. They bathe, feed, and move clients. They cook and clean. They assist with medication and using the toilet. In fact, they do almost everything except sit and act as a companion. And they perform these essential tasks usually for 2, 3, and 4 clients on a single day, and none of them are typically neighbors. Their work is emotionally and physically demanding, as evidenced by the fact that the rate of injury, on-the-job injury for home care workers is far above the national average. I ask you, what possible justification could there be for not giving these workers the right to receive the minimum wage and additional pay for overtime enjoyed by almost every other employee in this country? There is simply none. Third, the exemption is not only unsound employment policy, it's unsound long-term care policy as well. There's a growing shortage of home care workers due to the aging population and most consumers' preference to receive care at home as opposed to in an institution. This shortage is projected to increase dramatically. Low wages obviously contribute to this shortage, as well as to high turnover, which impairs the quality of care. And that's why advocates for consumers, for example, the AARP, took Ms. Koch's side in the Supreme Court because they understand, those who advocate for consumers understand that the greatest threat to the quality and availability of services is not the extension of the Fair Labor Standards Act, but the failure to extend the Fair Labor Standards Act, which will exacerbate the shortage of home care workers. Finally, opponents of the bill will tell you that it will increase costs and lead to reductions in services. But as the chairwoman has already mentioned, many states, including my home state of Illinois, already protect home care workers with their state wage and hour laws, and the quality of care in those states has not been diminished. Only a small percentage of clients receive more than 40 hours of care per week. Therefore, the fiscal impact will be modest as projected by the Clinton Labor Department. More importantly, there is simply no moral or policy justification for requiring the individuals who provide these essential services to bear that cost, whatever it is. There's no justification for asking these workers to bear the cost of our society's unwillingness to devote sufficient resources to long-term care. It will only exacerbate the shortage of workers and decrease the quality of care. I urge the members of this subcommittee to recommend adoption of the Fair Home Health Care Act. Thank you.
Thank you. Mr. Robinson.
Thank you, Madam Chair. Madam Chair, Ranking Member Wilson, and honorable members of the subcommittee, my name is Al Robinson, and I'm an attorney in the Washington office of the law firm Ogletree, Deakins, Nash, Moak, and Stewart. And as referenced earlier, I was formerly at the United States Department of Labor. Thank you for this opportunity to speak with you about the Section 13A15 exemption in the Fair Labor Standards Act, commonly referred to as the Companionship Service Exemption, and the proposed bill, H.R. 3582, the Fair Home Health Care Act, introduced by Chairwoman Woolsey. As you're aware, Congress amended the Fair Labor Standards Act in 1974, essentially to extend coverage of the Act. However, included in these amendments was this exemption for companionship services. And specifically, it exempts from the minimum wage and overtime protections an employee employed on a casual basis in domestic service to provide babysitting services, or an employee employed in domestic service to provide companionship services for individuals who, because of age or infirmity, are unable to care for themselves. In this provision, Congress also gave the Secretary of Labor the authority to define these terms. In 1975, the Labor Department did just that. They issued regulations found in 29 CFR Part 552. In particular, Part 552.109A, which is entitled the Third Party Employment Regulation, states, employees providing companionship services and who are employed by an employer or agency other than family or household using their services are exempt from the Act's minimum wage and overtime requirements by virtue of the companionship services exemption, the 13A15 exemption. Thus, the companionship services exemption has applied for more than 30 years to employees of a third-party employer or agency based upon the regulations of the Department, which were issued in 1975. Also, in this regulation, the Department exercised a conscious decision to exempt third-party employees with this exemption. As part of its rulemaking responsibilities, the Department's proposed rule was drafted to preclude the application of this exemption to third-party employees. However, based upon the comments, the final regulation that the Department issued did in fact apply the exemption to employees of third parties. And the Section 552.109 reads as it exists today. Thus, the application of the companionship services exemption to employees of third-party employers or agency is the result of a deliberate, well-reasoned rulemaking process and a long-standing interpretation. The rationale given by the Department is persuasive and direct. First, it effectuates a statutory language and is consistent with prior practices. The language of the statute is quite clear. The companionship services applies to any employee providing such services. The statute does not qualify the words any employee. It is not ambiguous. The statute does not contain words that restrict the application of the exemption. It conditions eligibility of the exemption upon the activities of the employee and not upon the employer who hired them. Many other exemptions of the FLSA do turn on the activities. I'll just mention a couple. The bona fide executive, administrative, or professional exemption in 13A1, agriculture in 13A16. So this is very in keeping with other regulations and other provisions of the statute. In addition to effectuating the statutory language, the application of the companionship services exemption to employees of third parties is consistent with congressional intent. Several statements in the record made no distinctions between the employee working for a family member directly versus a third party. Finally, the Supreme Court has been resolved any conflict in the Department's regulations. They found the regulation at 552.109 as valid and controlling. In the little time I have remaining, I would offer a few observations about the legislation. Its purpose is to reverse the decision of the Long Island Healthcare Koch case. However, I submit that it goes well beyond that intent. H.R. 3582 would limit eligibility for companionship services to the casual babysitter or companionship service provider in very limited circumstances, and that is they must be irregular or intermittent, they must be an individual whose vocation is not providing babysitting or companionship services, or is an individual not employed by a third party, in other words, employed only by the family or household of the recipient, and finally, does not work more than a total of 20 hours a week providing babysitting or companionship services to one or more individuals. I would welcome the opportunity to address any questions that you may have, and I thank you for this opportunity.
Thank you, Dr. Seavey.
Chairwoman Woolsey, Congressman Wilson, and members of the subcommittee, good morning.
Would you turn on your microphone, please?
My name is Dory Seavey. I'm a labor economist and director of policy research at PHI, which is a national nonprofit based in the Bronx that works to help to improve the lives of people who need home or residential care by improving the lives of the workers who provide that care. PHI stands firmly behind the Fair Home Health Care Act, and we've been asked to address the bill from a labor market perspective with a focus on public policy development in the area of long-term care. I'd like to touch on 3 points: the changed context for considering this bill, the problem of bad market signals and mixed policy messages, and finally a word about costs. I would direct you to my written statement for in-depth analysis. The context for this bill could not be more different than the one that confronted lawmakers in 1974 at the time of the last set of FLSA amendments. Profound changes in the provision of home-based supports and services have essentially eclipsed the companionship services exemption. Significant changes have occurred in 3 areas: in the duties performed by many of the workers now classified as exempt, in the home care workforce itself, which now totals over 800,000, recently topping the size of the nursing home care workforce, and finally in the size and structure of the home care industry. There is no question that home care occupations are now bona fide forms of employment that generally are not performed on a casual basis. Nonetheless, home care workers need and deserve basic protection. The remuneration of this workforce is notoriously low, with mean annual earnings of under $15,000. About a third of healthcare workers' home care aides have no health insurance, and shockingly, nearly half of these aides live in households that receive some kind of public assistance, such as Medicaid or food and nutrition assistance. Propelled by demographic and other trends, home care is a rapidly expanding multi-billion-dollar industry in which for-profits constitute the fastest-growing segment. There is also a booming consumer-directed market financed primarily by Medicaid, in which consumers serve as the employer of record or as joint employers with agencies. It's my opinion that maintaining the companionship exemption in its current form contributes to significant structural problems in both the caregiver labor market and in workforce development for the home care industry. Furthermore, the exemption works to subvert key policy goals established by the federal government concerning the development of the nation's long-term care system. From a labor market point of view, maintaining the current exemption in only one segment of the long-term care labor market creates distortions and artificial segmentation of caregiver labor markets across the entire system. Striking this same work performed by an aide in a nursing home is unambiguously covered by minimum hour and wage protection. By supporting this kind of disparity, the exemption impedes the normal functioning of markets and serves to undermine the development of a stable, adequate workforce of paid caregivers to provide home and community-based services. From a workforce development perspective, the exemption acts as a barrier to the overall status of this occupation relative to other low-wage jobs. Bottom line, it is basically impossible to construct any economic arguments as to why other domestic or home-based service jobs, such as maids, cooks, housekeepers, and gardeners, should receive this basic protection, but home care workers should not. Lastly, from a federal policy vantage point, not extending minimum compensation standards to these workers will only serve to send conflicting messages that undermine several important elements of federal policy. To mention the biggest one, this exemption in its present form works to subvert the federal government's encouragement of rebalancing, that is, the expansion of home and community-based services relative to those provided in institutional settings, such as nursing homes. The cost of this bill needs to be carefully and thoroughly explored on a state-by-state basis. However, several factors suggest that extending basic employment protections to non-live-in home care workers is unlikely to dramatically increase the nationwide cost of services or seriously disrupt service delivery systems, so long as steps are taken to adjust service delivery management accordingly. 4 quick cost-related facts to keep in mind. Virtually all home care workers currently are paid at least the federal minimum wage. Live-in home care workers would continue to be exempt from overtime under this bill. The vast majority of home care workers do not work over 40 hours a week. And in at least 16 states in the District of Columbia, either all home care workers or significant subgroups of them are already eligible for overtime pay because state laws exceed the federal standard. If the argument is that the exemption is needed to help make home care for the elderly and those with disabilities more affordable, then I would submit to you that the proper way to do this is not to artificially depress the market-based minimum cost of labor, but rather, in the case of publicly financed services, to make adjustments in state reimbursement rates, and in the case of private pay services, to use the tax code to subsidize the purchase of care. In closing, this bill offers Congress an historic opportunity to send 3 important economic and social signals. First, that home care workers should be on an equal footing with respect to all other low-wage occupations. Second, that within long-term care, the home care labor market should not have second-class status with respect to compensation, and therefore with respect to its ability to attract and retain workers. And finally, that federal lawmakers can work together to coordinate rather than send conflicting messages about the direction of our nation's long-term care policy. Thank you.
Thank you. I think you heard the bells ringing, but we have time for the final witnesses, the both of you, and then we're going to come back for questions if you'll stay with us. Mr. Dunby.
Thank you, Chairman Woolsey and Ranking Member Wilson and the other members of the subcommittee. Thank you for the opportunity to come here today to express the views of the National Association for Home Care and Hospice. NAC, as we call it, is a trade association. We represent the businesses that provide much of the care that we're speaking about today, home care aid services. Home care aid services takes on a different label under the Fair Labor Standards Act, companionship services. The National Association for Home Care and Hospice has long stood for the proposition that home care aides are the pillars of our long-term care delivery system. Without home care aides such as Ms. Butler, it wouldn't exist. It would have no chance of success. Society does not give them the level of respect and support that they deserve based on their dedication and their commitment to caring for individuals that most of us avoid even spending time with. The elderly, the disabled, the individuals who are shut into their homes and shut out of society's eyes. We agree with the goals of this legislation. The goals of this legislation are to improve the profession of home care aides, stabilize it financially so that it becomes something that people aspire to, dedicate themselves to, continue to work in with a living wage. From a business standpoint, the reasons are very obvious. A stable workforce makes for a stable business, and home care is a workforce-related business. But while we agree with the goals, we think that this action in this bill actually sends things going in the wrong direction. It sends things going in the wrong direction because, as Dr. Siery mentioned, market forces are at play here. And there's a big difference in home care and hospice than there is in many of the other market-driven economies. We do not control the price. We do not set the price. The price is set by Congress on occasion, federal administrative agencies, and state legislatures, governors, as well as state administrative agencies. When you cannot control the price, and the price does not change, if the providers of services are not reimbursed additional monies to cover additional costs, the only choice they have is cost avoidance. And while the sky has not fallen in Michigan, what has happened is limited, if non-existent, overtime services provided by home care aides. As a cost avoidance measure, the only option that was available to home care providers was to discontinue employing home care aides beyond 40 hours. There was no further increase in reimbursement. In fact, in Michigan, under the state Medicaid programs, the fights have been over decreases in payment rates. When we look at the cost of this legislation, it is a cost that this committee has to seriously consider. My constituency would embrace any change that allows them to pay a fair wage with overtime compensation and full employee benefits to home care aides, because the recruitment and retention costs, the nightmares of going through background checks for workers who come in with felony-level backgrounds is just an unacceptable way to operate a long-term care system. We do not know what the exact cost would be, but I'll give you a few numbers. Today, $15 billion a year is spent under the Medicare program for home health services. About 25% of that are home health aid services. In hospice, $9 billion a year spent under Medicare, with about 20% home health aid services. In excess of $20 billion a year is spent in state Medicaid programs on personal care supports. And then we have many more programs in addition to that, from the Administration on Aging through TRICARE and even the Housing and Urban Development programs for home care services. These are all federal and state funded programs. And there are local home care programs like in the City of New York, where the City of New York estimated that the cost of overtime compensation under this bill in its evaluation of the Supreme Court case would be $100 million in New York City alone. As I stated earlier, the pillars of home care deserve your support, but they can't get it in isolation with all the other factors that are there. So as an alternative to moving forward with this legislation, we would recommend this committee take a broad-based approach. Look beyond just overtime compensation. Minimum wage is not an issue. These workers get minimum wage. And instead, I offer 5 different areas in which this committee should address that will ultimately implicate compensation and benefits. Number 1, mandate all federal and state programs that finance home care aid services to reform payment rates to accommodate increased costs of improved and appropriate compensation. 2, require all federal and state home care programs to provide the necessary financial support for a basic health insurance program. This Congress is debating S-chip at this point in time. We're talking of 200 versus 300% of the poverty level, but these individuals will not be covered through any S-chip amendments that are under consideration today. Health insurance for healthcare workers should seem to be a minimum right. Number 3, provide support for programs that establish career ladder opportunities for home care aides, including scholarships and grants for higher education and training. We have that going at the National Association for Home Care and Hospice now, but our few dollars that we can offer only goes a short way to bringing individuals who start as home care aides who would like to be LPNs, RNs, and other healthcare workers. Number 4, establish economical and efficient background check systems to allow for expedited screening of applicants of home care aid employment. In Wisconsin, 30% of applicants for home care aid jobs were found to have felony-level backgrounds. We don't want them in the system, but we don't want to keep individuals like Ms. Butler waiting in the wings to come into the delivery system as well. And last, require consistent employee protections across all forms of home care aid employment, including workers' compensation, unemployment compensation, OSHA job safety standards, and worker qualifications. A trend across the country is to bring in individual providers without that protection. So thank you for your time and your patience.
Thank you, Mr. Dunby. Mr. Claypool.
Chairwoman Woolsey, Ranking Member Wilson, and members of the subcommittee. Good morning. I'm Henry Claypool, the Policy Director of Independence Care System, a nonprofit managed long-term care plan based in New York City, serving more than 1,200 people with disabilities living in their homes. Thank you for inviting me to testify today. I'd like to give you ICS's perspective on the Fair Home Health Act, as both an organization that pays for the services of direct care workers and as an advocate for services for people with disabilities. My comments are also informed by my own personal experience. I'm a former Medicaid beneficiary, and I continue to rely on the supports provided by direct care workers. We support the enactment of the Fair Home Health Act, and we believe that there are 3 major policy challenges that this legislation seeks to address. 1, antiquated Department of Labor rules must be readjusted to address the current shortage of direct care workers. Competition for workers to take jobs in the service sector is fierce, and it makes no sense to continue to put direct care jobs at a comparative disadvantage by allowing the erroneous categorization of workers as companions to persist. 2, federal labor policies should be conducive to delivering high-quality services. It can be difficult to find someone who is capable, competent, and interested in helping with often intimate personal needs like dressing, using the bathroom, and eating. The result is that many people who rely on community-based services struggle with quality issues on a daily basis. To assure quality, all workers who provide non-casual, non-live-in, long-term services should be fully protected by FLSA. 3, the current exemption for some FLSA protections for direct care workers should be eliminated or at least narrowed so that these protections apply equally to direct care workers across all long-term services settings. For the disability community, the #1 civil rights issue in this country is the need to expand access to community long-term services so that Medicaid beneficiaries who need these services are not forced to be isolated in a nursing home in order to receive these services. When community-based direct care workers are exempt from wage and hour protections, it exacerbates the institutional bias by making direct care jobs in nursing homes more attractive than comparable jobs in community settings. As the subcommittee moves forward with its consideration of this important legislation, we make the following recommendations. Consult with the Energy and Commerce Committee to fully consider the ramifications for the Medicare program. The Medicaid program. Medicaid is an extremely complex program, and the Energy and Commerce Committee has accrued very significant expertise and may prove valuable to the subcommittee. Redefine the live-in exemption in a way that provides narrow exemptions from FLSA wage and hour protections. While ICS believes that the Department of Labor rules have been misinterpreted to exempt too many workers from FLSA standards, we do acknowledge that some exemptions are appropriate. Careful consideration should be given to reclassifying certain direct care workers as live-ins. This step should be taken, however, after consulting with groups that represent consumers and independent providers. In closing, I'd like to thank the subcommittee for its efforts to protect direct care workers and for considering how to ensure that Medicaid beneficiaries who depend on community-based long-term services are not adversely harmed. ICS looks forward to serving as a resource to you as you continue to consider this important issue, and we urge the Congress to enact the Fair Home Health Act into law. I look forward to answering any questions you may have.
Thank you. We will be back.